7:03, I'll call us to order. Thanks, everybody, for being here. Before we consider the minutes, I do want to make an announcement that November proved to be more challenging than some other months for scheduling the board's business, and that included policy committee. So we've decided to have that November Policy Committee meeting on Wednesday, November 19th at 1 p.m. So board members, please make efforts to be here if at all possible. And I appreciate everybody's flexibility, and that includes staff. So with that said, is there a motion to accept the September 23rd policy meeting minutes?
Motion to accept.
Thank you, Ms. Gordon. Is there a second?
Second.
Second by Chair Haggerty. All in favor say aye.
Aye.
Any opposed? All right, the minutes pass. And we will start with a very minor revision to 4318, the student use of wireless communication devices.
So the board passed this policy back prior to the official adoption of the new legislation. And so when we did, we adopted language that said the devices should be silent and put away. So what you will see on page 2 of the policy for both elementary and middle schools and for high schools, you will see the language shift so that it says that they are to be turned off and put away. The official statutory language is that at a minimum, the devices shall prohibit students from using, displaying, or having a wireless communication device turned on during instructional time. So we have switched the word silenced to the phrase turned off in both those sections. We did make one additional revision based on feedback we got at the start of this school year, and that is in the 4th paragraph of the opening of the policy. We had questions from some school administrators that wanted to know, does the policy mean that students can't use their own personal laptops for instructional purposes? And that was not the intention of the policy. So we have clarified in that paragraph so that it reads, this policy does not apply to district-issued and managed devices or personal laptop computers that are used exclusively for approved instructional purposes consistent with Policy 3225, Technology Responsible Use.
Are there any questions from board members?
Ms. Simmons, if you can grant me just a quick second. I'm fine with all of the statutorily required changes. I was just going back through the cross-reference to the other policy, just because I'd had some other parents that had contacted me about that same issue that Dr. Crane had raised. So I just wanted to make sure that it was clear here.
Yeah, sure, Dr.
Yeah, so in the definition of being turned off in reference to a smartwatch, how does that work?
Good question.
That's a good question.
I think it has to be turned off.
We did have the
Powered
question.
off.
We did have a question this week, last week, from a principal who has a student with a pair of smart glasses that are prescription. And so we are wondering, they're prescription glasses. You can't tell a student to take them off, but you can we tell a student you have to power them down for all of the other functions?
Power is not required for use of the lenses.
Correct. Power is not required for use of the lenses. And smart glasses are covered in our policy, the intro language.
Yeah.
So that's a good question, Dr. Ng, and one that we've already been answering with regard to another smart device.
Dr. Actually, Chair, this is
Yeah.
mine. Dr. Crane, I just wanted to bring up, we referenced the Technology Responsible Use Policy, and from your description, I just wanted to double check, does this policy restrict families from bringing like a personally owned device other than a WCPSS Chromebook or does it restrict use of those types of laptops, or is that just like a rule or a practice?
We do not restrict personal laptops used for instructional purposes.
Okay. So then follow up.
Sure, of course.
If a school was restricting use of a personally owned laptop, how should a parent address that situation if they've already addressed it to the principal who's denied use of that laptop?
That needs to be pushed up to central services, because if the principal is clearly not following the board policy, then there needs to be intervention at this level.
Okay. And honestly, I think there just might be some confusion, again, based on the mobile device policy, what it applies to, and there might be some schools that are reading it overbroad than the existing definitions, so, all right, thank you. Thank you, Chair Evans.
Mr. Hershey?
2 questions. Does the state law say that does it just reference personal devices when it says it needs to be turned off?
Yes, and it defines personal devices, and it does include, read the statutory definition. Let's see. Wireless communication device is any portable wireless device that has the capability to provide voice, messaging, or other data communication between 2 or more parties, including the following: cellular telephones, tablet computers, laptop computers, paging devices, two-way radios, and gaming devices.
Not smartwatches?
It doesn't specifically include smartwatches, but smartwatches are included in the policy because
Right.
you can text message.
Right, but we do say they need to be disabled. Can we not, do we need to specify that glasses may be worn, but do we need to have specific language about the prescription glasses, the smart glasses, to say that has to be disabled as well?
I think you could, although the language in the updated policy language says they have to be turned off, which would suggest, unless I'm mistaken about how these work, the lenses will still work the prescription lenses will still work. Any ability to exchange data through wireless will be turned off, powered down, so that, they're still useful as.
I guess
So I
I'm
think
not
that's
understanding the
covered.
distinction between the glasses and if we have separate sentences for smartwatches.
It seems to me that that should be addressed with the smartwatches
That's what, yeah.
sentence, which is in
A.
the third paragraph,
Yes.
intro paragraph.
Above A.
So would you suggest, for example, in the 3rd paragraph, for the sentence that starts with smartwatches may be worn and used, are you interested in changing that to smartwatches and smart glasses may be worn and used throughout the school day, but any features that require wireless connections to a smartphone?
I don't know. I don't know enough about smart glasses to know how. But my point is just that if the concern is smart glasses, we're addressing smart watches. Why would we not just address it in the same way?
Right.
Yeah, I think that's a good suggestion, and I think Dr. Crane's suggestion where to put it is spot on. There's a sentence in the end of the 3rd paragraph about addressing smartwatches. We could easily add smart glasses, so it would say smartwatches and smart glasses may be worn and used as watches and glasses throughout the school day, but any features that require wireless communications must be disabled. And that gets you complies with the statute and makes it clear you can still wear the watch.
Yeah.
Yeah, still wear the glasses. Yep.
Okay, I'm happy with that.
Cool.
And I think that works because one of the issues we can deal with is technology that changes all the time and not knowing what that is. But I think the 2 prevalent devices now will be smart watches and smart glasses. So at any point, if that expands into a whole bunch of stuff, then you can go back and amend the language to cover all of that.
Okay, cool. Thank you.
Okay, board members, any other questions or revisions?
Chair Edmonds, I move the policy for first reading.
Okay, so does somebody want to second that? Second. Thank you. So I was initially going to suggest that go on consent for November 4th because it was so minor, but I don't think that's true anymore. I think the public needs a minute to look at this because of the smart glass issue. So just to be safe, can we do that on consent on November 18th? That would be part of the motion. Everybody good with that? Okay, so all in favor for this going on consent for first reading on November 18th, please say aye.
Aye.
Any opposed? Great, thank you. And we'll move to 8341 settlement. And this has an R&P with it.
Good afternoon, Chair Edmonds and board members. So this policy is another one of the migration policies. And originally, we had looked at creating some designees in alignment with our contract signature thresholds when it comes to settlements, so that the superintendent did not necessarily need to be the signature on the settlement agreements. So finance officer certification is required on all contractual settlement agreements where there's a financial implication. But as we looked at doing this and creating an RMP or doing a revision to the settlement, we found that there is an agreement already existing in the new state board policies. And so we went ahead and made some changes that you'll see in blue. And we worked with legal counsel to help make those changes, and then to also add superintendent designees, in which Dr. Taylor provided his support in those recommended thresholds.
So one question I had, just to make sure I understood, A, that is crossed out, did you all, that was from the State Board Association, and you all rephrased it for what you wanted in the very top. Is that correct?
Yes, that is correct.
And then I have a concern about the RMP of the designees, but I'll save that for a little bit later. Board members, does anybody have any questions or comments about what you see under Policy Code 8341? Yes, Ms. Caulfield.
Thank you. Do we give the authority for the super to approve any amount now? How do we currently do it?
Currently, for contract agreements, we have different thresholds. So at 100,000, the board chair signs contracts, and we bring those contracts to the board on consent for approval. Below that, we have designees, which are called budget managers. So below $10,000, a budget manager, whether it's a school budget manager as a principal or an assistant principal, if they're a designee budget manager, they can sign up to $9,999. And that's because they are a budget manager over their resources at the school that's assigned to them underneath their school cost center. Similarly, we have the same sort of structure in central services. Budget managers who have gone through training, and they are in a certain position that is allowed to be a budget manager. Your senior administrator, director, senior director, and your SLT, area superintendent, assistant superintendent, and your chief officers. And so those thresholds allow at 10,000, an area or assistant superintendent must sign, and they can sign up to $89,999. At $90,000, the chief officer must sign above that threshold. So those are our current thresholds that we have.
For contracting.
For contracts,
And then
yes.
Contract approval.
And then
For
the
contract
thresholds for
approval.
settlement are in the section D of the policy, and they're the same. It's all being just
Trying to mirror.
merged.
That's the
no
question
no
that
change there.
we had,
Yeah.
we knew there had been a change with the contract authority. It seems like,
Yes,
But-
but the settlement
but
is not.
Settlement authority is
Settlement.
separate, and it's
Okay.
addressed in this policy, and there's no change to that.
Right.
Here, it's in blue just because it's being merged with another policy.
You, last November, you approved a revision to that in Section D, where you agreed that the superintendent is authorized to settle claims by the payment of up to $30,000. And then all settlements in excess of $10,000 that are approved are reported to the board. So the superintendent is currently authorized by policy to settle any claims up to $30,000, and anything over $10,000 is reported to the board. So that same authority comes here. The change is that currently the policy says the superintendent is authorized, and in Section D, the superintendent and superintendent's designees are authorized, and those designees are in the RMP, and they are chief officers, assistant superintendents, and senior director for policy and education services. Again, still, anything over $10,000 would be reported to the board as required by the policy currently. It just adds "and designees" so that the list of designees in the RMP are added, that the superintendent can designate those folks.
And when do we get these reports if this happens?
I believe in speaking with Rod Malone, they were going to be compiling a list to bring
Yeah.
that forward to the board.
Yeah, Rod did tell me there is a list being compiled as we speak. I think we're almost done with a current list.
Is that like for quarterly, yearly?
I don't
How-
think that the policy doesn't specify how, I don't believe how frequently.
It does
You
not.
could add that.
That is,
Um,
yes. Yeah.
I mean, I think the plan would be, on a rolling basis, like right after the settlement going forward. I think we're just right now catching up with the policy with the list of the recent settlements. But that, the board could add a timeframe.
So I would request that we add a time frame on that, and I know you said you wanted to wait for the designees, but it's kind of incorporated into
Oh,
this
yeah,
policy.
yeah.
so
I was just
it's going
referencing the
on.
RMP, which is why, no, I'll get to that. But, and if you have a comment about that, go ahead. But I wanted to ask, well, a couple things. So the settlement reporting, if we add reporting to the board, that would go in Section E?
Yes.
Okay. Ms. Caulfield, did you have my suggestion would be quarterly, but
Yeah.
do you have?
No, that was one of my questions is for E, when it was reported, so I was hoping that it would be quarterly. And as far as the designee, I feel like we make other decisions based on the information that comes to us as a whole. So I feel like it should be something that is reflected through the superintendent to us directly. How do we make those broad decisions when other people are making decisions that, I just feel like there's a path for disconnection there if we pass that on.
So my concern about the authority was specifically with the area superintendents. And I was referencing, it's in the RMP, it's not, I don't see it in here. Let me-
We actually excluded area superintendents. They are not an authorized designee. It is chief officer and assistant superintendents, and then the senior director for policy and special education services. They often are doing the mediation, in which at that point in time, a decision can be reached, then that policy individual is able to do that. Now, the settlement is not confirmed until I've signed and certified that funds are available for that contract.
Right, and I'll be honest, I actually read that as area superintendents and not assistant superintendent, so thank you. I just read it wrong earlier today.
We did have that discussion, so thank you.
But let's, Mr. Hershey?
Have we, for other policies that have a superintendent's designee, do we spell that out ever? Is this unique?
Usually
that we
not.
are
This is different. When I discussed with my colleague who had worked with staff on this, and she shared, I think just because settling claims is particularly sensitive, issue. In some cases, it may make sense to give the superintendent more flexibility to designate different people. But when you're talking about settling, actual lawsuits or potential lawsuits, it really is an area where you don't want to have any misunderstanding. Someone said, well, I had a conversation with Dr. Taylor, and I thought he had authorized me as the designee. I guess I misunderstood. We have it right here in the RNP, and he can update the RNP at any time.
Great, okay, thank you.
I'm not comfortable with anyone other than the superintendent designating, deciding above 10,000. I would rather, I'm fine with it at the 10,000 threshold, but if it's up to 30, I think between 10 and 30, I think that should be the superintendent specifically.
I agree.
Yeah.
So process-wise, what would that mean? It would go to that level of leadership, and then it would just be routed again for the superintendent for his review and signature?
Yes, so the way that we have it set up right now, we have special education services settlements, and they use a special DocuSign link, and it immediately comes to me. We review it to make sure that internally we have it covered when it comes to risk management and insurance, so that something that we've reported on our policy, and then I will review it for funding. If it's, well, right now I route them to Dr. Taylor. And so I get his signature on those, and we would just modify our routing to go to the appropriate approver.
Follow-up. And then just by volume, do we know, if this is currently what we do right now, where it still has to go to the superintendent, then requiring that it still go to the superintendent for anything between $10,000 and $1.30 doesn't increase the workload or increase the administrative burden, does it?
No.
Okay.
So one question or thought on this is, the only thing I could foresee as potential challenge here, and I don't know enough about how these cases are actually litigated. I don't do a lot of special education litigation. But if the senior director for policy and special education services is attending a mediation, it may be that the mediator needs a decision there during the mediation to close it out. And if it's something gets routed to Dr. Taylor through DocuSign and he's in meetings all day, I wonder if that could create a problem where we can't close that out.
Yeah, Mr. Nieder?
And again, just for the board to consider, it's obviously a board decision, that by shifting the dollar threshold requiring the signature of the superintendent to be different from all other fiscal business decisions, and a settlement is a business decision, that creates an inconsistency. And again, the board may look at a settlement as a different type of business decision, but that would be unique. And every one of these has to be routed and signed off by, and did you cover the routing process? Okay. And approved by myself, approved by Ms. Posey and a slew of others.
Say more about your concern about that inconsistency,
It's not a
please.
strong concern, but just, it's an inconsistency if we're saying that certain levels of leadership have the authority to make a business decision, and entering into a contract is a business decision, and a settlement is really another form of a contract, negotiating a need to meet a need of the district in exchange for making some type of payment in exchange for it.
Mr. Hershey?
But again,
So, David, if I can summarize so that I understand, when Trish was walking us through contract approval levels earlier, she was saying that assistant superintendents can currently authorize contracts of up to $989,000.
They're $10,000 to $89,999.
$10,000 to $89,999. An assistant superintendent can already authorize that contract. So if we limit them to under $10,000 in settlement, that is what's inconsistent with current
correct.
fiscal authority that they have. They already have fiscal authority for spending up to, and so the question David's raising is, you may consider a settlement a different thing than approving a contract for services or a contract for in any other way. I think that's what you're pointing out.
Hang on, I'm going to work my way around, I see all
Oh,
the
I thought you had
hands.
said-
I do view it differently, speaking as chair, but I want us to we're good on time, so we should have this discussion. I'm going to go around, Mr. Hershey.
How often are we having these settlements? Because we have a bunch of contracts. Are we having one settlement every 2 months? Because that's different than the
The
number.
frequency is greater than that.
Can we have a number? Because I don't have any sense.
One, maybe 3 or 4 a month.
Thank you.
Dr. Ng, did you have anything?
Not yet.
Okay, Ms. Caulfield?
So just to comment on what you said about getting the contracts done, if that's the way that they want to do it, I do think it should be separate. Because having a contract and approving that to get the job done is very different from us being in the loop of what is being settled, because that means that something has actually gone wrong that we need to address and possibly even change policies or procedures so that it doesn't keep happening. I think it's two totally different things. So either it gets separated, or I find it difficult to not have it go up to the top so that Dr. Taylor knows, hey, this is what's happening. We're seeing you're saying this is happening like 3 or 4 times a month, so what are the things that we need to kind of pay attention to? Because that would have to hit Dr. Taylor and then kind of come back down on how to rectify it going forward.
Ms. Rice?
Thank you. One, I'm in agreement with our chair and probably the rest of the folks. I think that settling a lawsuit takes away from board authority. I think that giving staff that level of broad authority is, to me, removing the purpose of a settling of a contract versus rendering services to 2 different playing fields. The other part I kind of want to go back to, this is the answer that I was looking for when Ms. Schofield and we all were talking about 3 months about giving information. Ms. Posey just told us that we're settling stuff, at least 3 to 4 contracts a month. I think at that rate, we need to know at maybe the second school board meeting of the month, how many have we settled so far? Even if it is those 3 or 4 versus waiting on a 3-month basis to hear about 10 to 15 suits that's been settled, that's beyond our scope of knowledge at the end.
Ms. Rice?
They're not suits. It's not, we're not settling. We may be preventing a suit. Is that fair?
Yes.
We're not settling a lawsuit.
It's the settlement of a claim.
It's a claim.
Not necessarily and likely not a lawsuit. And just one other distinction, the number that Ms. Posey shared, she believes, without having done formal research, as far as a couple, 3 a month, to be an accurate estimate. But that said, you may note anything over 10,000 comes before the board, and you may note as a board that you've not seen that number, so the majority of those are under the $10,000 threshold, just for your information.
So could you also give a couple of examples of claims that we settle, because we want there to be a clear distinction of what that looks like, because in your mind, you're thinking that we're settling a lawsuit or somebody has filed a suit and we settle. It could actually be something that's not necessarily a lawsuit.
Right, and just let me share my clarity so that you all don't think, no, that's just a switch of words. I understand what we're talking about. I apologize if I have to be very specific in what I'm saying. My apologies for the word mix-up. I do understand that we're not talking about the lawsuits consistently that we brought here on first and third. So I do understand that we're talking about preventive cases so that we're not literally entering lawsuits. So I don't want to waste our time trying to clarify something that I do understand in reference to that. But I would like to hear about our numbers. So I'm not confused on that end. That was just a shift of words, so it's okay.
Certainly.
All right.
I do see things about compensatory hours being provided. So the individuals from the special education area, it does come out of their funding where they're basically paying for a service. So that's where I think the contractual piece of it, the department has agreed, yes, we recognize we need to provide compensatory hour services for students, and that's what the agreement states, and it just comes out of their regular budget to provide those compensatory hours. I do see a few of those.
Ms. Gordon? Well, I will say, based off of what Ms. Rice has said, I am confused as to, like, I would like to know, like, you all's distinction between settlement and contract, like, examples for me, because, like, I'm sure, like other board members, I do feel like they should be separated.
And they are currently, just to be clear, so that currently the superintendent's signature authority on contracts is, I believe, $100,000, but on settlements limited to $30,000. So the board has already made a decision, I think, to hold for itself more authority over settlements, which it has the prerogative to do. So there's no change in that here. All this language on the settlement authority is your current policy. It's just being carried over and consolidated with other language. Just want to be clear on status
It's
quo.
also specific to settlements, not contracts.
Correct.
What we're talking about, yeah.
Correct.
Okay.
Other contracts, the superintendent has more authority. That's the board's decision. You could change that and modify that at any time, but right now it's $30,000 limit for the superintendent or designee.
We'll continue to go around. Did you have follow-up? No. Okay. Chair
So
Hagerty?
this is just though to build on these questions. Could you just give us some illustrative examples where you have a settlement over maybe a complaint or a grievance, not where there's been litigation, but just some examples of how this works as opposed to a negotiated settlement coming out of a lawsuit? I think it'll just be easier for everybody if we could see some examples of that day to day.
So I think compensatory services
think
is certainly a
compensatory
good example to
services,
start.
Could be a reimbursement for some medical expenses where a parent went and had their child examined, and so therefore they're reimbursing them for that. Things like that. They're very small in number, but I cannot log into my computer without my phone over there.
Well, and I would also add, for everyone's knowledge, I cannot think of a time when even a relatively minor settlement under 10,000, although the superintendent may not literally be signing off on that before it's executed, that one of the board's attorneys is not directly involved with that issue.
So, and correct me if I'm wrong, but I think a lot of these cases are going to be where the district is working with a family on an area where they've had an agreement and something has come up where the family has disputed something in the agreement. You were supposed to provide a service or you were supposed to reimburse something. The district had said we weren't going to do it. The family's come back and said, well, no, here's the agreement. And the district has decided, okay, so we did need to do this. And really, it's a way to help avoid lawsuits and to reach settlements or agreements to help mediate some of these disputes where there's been a disagreement and we agree with the family and we're just trying to make it right, as opposed to, well, here's a lawsuit, here's what we could have to pay, here's what we could risk, and then something like that. These types of issues seem to be more administrative and about just kind of like solving the problem and helping everybody move forward. Is that accurate, or did I?
That is. I can give you one example that both parties are agreeing to designate a specific individual to work on the IEP team, basically as
Consultant or
to advocate
consultant.
for the child, setting aside a specific amount of compensatory hours as well as speech therapy.
Mileage reimbursements sometimes comes up.
And a legal, there's some attorney fee reimbursements, but it is below the 10,000 for this particular agreement.
So Ms. Rice and then Dr. Ng.
So thank you for the clarity. I definitely want to say that with the clarity, and I'm hoping that if this is the change that you all are seeking, that you will be able to service families more efficiently, and that they're not waiting on certain things any longer. I know in that EC space, those are challenges, you know, when you talk about the compensatory reimbursement, to me, that's a huge bell ringer. So I'm hoping that, is there a time frame, or how quickly are you all going to be able to do a turnaround for these families so that they aren't waiting longer as they would if they had to come back to the board and do all of that? I'm hoping that we'll be a little bit more efficient in this process.
Yes, Mr. Rice. I believe the intent of having the Director for Policy and Special Education Services, especially when they're having their mediation and discussions, Neil, if you, I believe, because Barrington Smith, we talked about the quick turnaround and for them being able to sign it,
Yeah.
that everyone's agreed to everything, and it just kind of resolves everything. Still has to come up for a final signature, and they're aware of that it must be certified by the finance officer.
Just having someone with authority in mediation is usually
Yes.
important, not someone who
Okay.
says, well, I'll recommend to the superintendent that we settle this for $5,000, but I can't promise until I get in touch with the difference would be that they could say, yes, I will, this is approved, and then it'll still be routed per current process, but they would have the authority to make that decision.
Much more clear. Thank you.
Dr. Ng and then Ms. Coughlin.
Yeah, so I'm just thinking in terms of some kind of a compromise between expediency and transparency, is whether it could be that we get the report on a monthly basis rather than a quarterly basis, so that we can, you know, if there were some issues that are needing to be addressed, or that we need to, or just all of us need to be aware of, that we could be aware of it earlier rather than later. I mean, just a thought for all of you to think about.
I was going to ask about the special education services. You said in case like the superintendent is busy or what have you, what have we done so far up to this point?
So there is an individual that's there, but it ends up coming, they end up signing it, but then there's a line for the superintendent and there's a line for the finance officer to certify funds. So it does go through that process. I mean, we are quick about it. If I hear from Barrington Smith that it's a priority, I will usually send a message, and we have DocuSign established where we can pull it up on our mobiles to approve those things if it is something that is urgent to move forward quickly.
So it's, if I'm understanding it correctly, this is more to streamline the services so we could keep things flowing. So is there a way to put, because when you say settlement, I do find it to be very different from a contract of services, like you mentioned the word rendering services. Is there a way to add examples of what the settlement is?
So I had a similar question, wanting to know about that concern to keep the services moving and get going as quick as possible. If we could designate the special education scenario as opposed to other types of settlements, to give the authorization to that person in a special education case, claim.
You could, you mean in the RMP, I assume, where the designees are specified and then have more, or?
That is your wheelhouse.
Okay. I guess I'm just trying to understand the goal so we can help you get there. To me, I think and again, I don't have a full sense of the full scope of issues that are settled. We could, kind of review, a few months' worth and kind of get a better sense of that if that would be helpful. But my only concern would be for limiting the authority to the superintendent would be anything that requires someone with authority out of mediation, which is the thing that comes to mind is special education, but there could be other types of mediations too. Could be even litigation, a small dollar amount. You can have a lost small claims case that would make more sense to settle than to pay attorneys to go defend, for example, and maybe it's a $500 payment. But having someone with the authority to make that decision promptly helps you avoid the further costs.
Let me try to restate what I think, just so that we're clear on what the goal is. So I brought it up that I was uncomfortable for anything over 10,000, between 10 and 30. I believe that should go to the superintendent and not a designee.
Right.
However, with respect to the special education issues, because we don't want to hold up services for families and students, could that be a distinction, specifically within this 10,000 to 30,000 threshold?
Yes, I mean, I guess you could make any kind of distinctions that the board wanted.
And
Yeah.
I would look to staff to help us work that out, whether that needs to be in policy or R&P or
Right.
how, that.
Okay.
Ms. Caulfield?
And that's why, just to follow up, that's why I was saying if we had a list of services, then we would be able to see what it is that we would be able to move versus what we don't feel should escalate to Dr. Taylor instead.
I'm hesitant about a list because I don't know that it would be exhaustive, and so I would be curious as to what staff would come up with.
Right.
You know what I mean?
Well, that's
That
what I
makes
was
me,
thinking.
that
It
gives
would
me a
be
little
With
pause.
special education.
Right.
And anything else should be steered.
Yeah. Mr. Nieder?
A couple things. Let me share perhaps another possible example. Let's say there's some type of relatively minor injury to a student. There is the potential that there may have been some kind of fault on the part of the district staff, and there's maybe allegations from a parent of some type of legal action, and staff, again, in working with one of the board's attorneys, makes a financial decision within their level of authority under other policies that it is in the best interest of the district to settle this before it becomes a legal matter. But just because it's not a legal matter doesn't mean we're not working with the board's attorneys. And it may be for a few $1,000s, and that might be another example to give the board some sense. And if I could, while I have it, I too would share the concern, separate from that, of having a list of things for two reasons. One, it may not be inclusive, and second, it could be an advertisement.
So respectfully, the example you gave, if it's a few $1,000s, that's not what we're talking about. We're specifically talking about the 10 to 30. So I don't hear anybody having a problem with up to $10,000 other, designees, settling those claims. Yes.
Sorry to keep going back, but then with those last couple of examples, I'm kind of back to my original thought where I feel like it really should go to Dr. Taylor. I mean, unless we wanted to create this policy for special education solely and leave the rest of it out. Because if there's other things that are building and happening, and you're saying like 3 or 4 a month, and maybe they are special education and they kind of go through and it speeds it up, but what if they're not? And we're not privy to any of that. And hopefully we do change language that it comes back to quarterly, but now are we getting, like when something comes before us, we actually get the details and we make a decision instead of just getting a report. It's kind of like how we work with the bidding, like they do all the work and then it comes back and just says, by the way, this is what we did. We're not really seeing the depth of, is there something that we need to pay attention to so that we can be more proactive with the amount of things that are coming.
So what are you suggesting?
I'm suggesting that we have a policy like this for special education services, but for other settlements, I don't think it should go.
So are you suggesting any changes to what you're seeing today? Because this is just general about settlements.
Right, I think it's too general. I'm saying that it would be fine to have something like this for special education because of what they were saying, how you could expedite it, but other cases should go before Dr. Taylor.
So can I go back for a minute?
Please.
Because I think the recommendation is that anything $10,000 or less, you would be okay with the designee. And so is that where we settle? That is something that you would be?
Can we get a thumbs up or thumbs down on that piece, on that part?
And-
10,000 or less?
And just to confirm, that's the status quo now.
Well, now it says anything 10,000 and beyond has to be reported to the board, but I think this is what we're adding, that the designees would now be able to do 10,000 less, well, that's not the case now.
Okay,
it's-
so
it's
that
all-
is a change.
Yeah.
Okay.
I'm sorry, I'm not,
Isn't that correct? Yeah. So now it's all the superintendent, but by adding the designees, they would have been up to 30,000 as well, but you said that you would prefer that to be
I see.
10,000 or less.
Right.
So that
Except
is.
for special education services, I think, as Edmund said.
So we're asking for up to 30,000, and we're asking for it to not be solely the superintendent, but to be designees.
Yeah, so what the board has said is that you would prefer that designees not go beyond 10,000.
correct.
So that would be I think the change that we would put in.
Except for special education.
If you add that in now.
Right, that's what we're saying,
Right, right.
except for special education.
I just don't feel comfortable with it going back to, like he made an example, going back to our board attorney. We're kind of out of that, and it's really the board who should be deciding that, and isn't Dr. Taylor signing it on behalf of us? So if we're now giving...
Attorneys don't approve settlements ever. We only give you guidance.
Right, but
It's
he
always
was saying that
it's
they
always
would
a
make the
client
settlement
decision.
based on speaking with you, but
I think he was
we
just
are not
pointing out.
in that
Agree.
conversation.
I agree. I'm just pointing out that the attorneys
Right.
would never approve a settlement. That's not allowed.
Mr. Hershey, Ms. Rice, and Mr. Haggerty.
It would be extremely helpful for me, not going to speak for anyone else, if you provided us with like the last 6 months of settlements, because I'm making a decision on something that I don't see any of this stuff. I don't know what settlements have been made for what amounts under a certain dollar. So we're talking hypothetically about a bunch of things. I don't know what is actually being, like, happening. So it would be extremely helpful to have, I would propose that the under 10,000 is fine, but otherwise we keep it status quo until we actually get that information. So the board, or at least as a board member, I know what we're actually making a decision about. Because this is really like, hey, here are these settlements. Okay, what settlements? How much are they normally? What are they for? Historically, we have the data, but I don't have access to it.
Ms. Rice, and then Chair Haggerty.
I just wanted to clarify, Madam Chair, since my colleagues were talking, we're talking specifically about the designees having up to $10,000 to make decisions, except in the case of special education. I just wanted to make the plea around, I was just hearing a colleague say, well, shouldn't it still come back to us? But if we're doing special education and we understand as a district what is legally necessary for that student to really have what they need, and it's legal within our attorneys to make sure that we will be able to do that. And the final part of that is, are we indicating, Neil, that we need to actually place that part in policy about except for special education? Because I don't think that particular piece is in there.
Correct.
I just think that if we're intentional about closing the gaps and doing the wraparound services around special education, we need to make sure that we technically, hate to see it, put our money where our mouth is, so.
Mr. Haggerty.
I just want to, I'm not going to speak out against transparency and accountability or anything like that, but just as a practical matter, I just want everyone to think and appreciate the more reports we create, the more reports that are generated, the more reports you are asked to review, that requires then the actual time to take and read and review them. And, for special education, for example, for anything that could be a potential legal matter, but anything regarding student confidentiality, the communication of confidential information, confidential documents, names of students, possible disciplinary, all of these things are opportunities where there can be information that's mishandled. Confidential information can be inappropriately shared or passed or responded to, and it puts more legal risk and responsibility on the district as well. So the idea of we'll see more, we'll review more, we'll have more accountability is a good idea, but just, I want to put out there as a word of caution, in practice, that's going to come with a lot more requirements and a lot more burdens on each of you individually on how you read, review, store, process this information, and, you know, even something as simple as like printing out your email to read later could subject you to like liability and violation of student privacy records. So I just want to let you know that it comes with a cost.
So it is clear to me we need more discussion on this. So what I'd like to do is I'd like to ask staff and Mr. Ramey to huddle up between now and the November Policy Committee, which is November 18th. I don't want to push it to a different agenda. I'd really like for this to come back to us on November 18th, and let's see if we can land in a better place than I think we can today.
So for my clarification, what I heard was we still have some discussion about whether the reporting of 10,000 and above should happen quarterly or monthly. We haven't decided that.
Correct.
I did hear confirmation on, as far as me preparing a draft for consideration, we could add a paragraph after, and under delegation of settlement authority, a paragraph addressing potentially a superintendent's designee for special education and that authority, and then an additional paragraph about superintendent or designee up to $10,000. All of those things I heard general agreement about and would appear in the next draft for further consideration along with anything else you might request.
I think you've captured it well. I would like to encourage board members, it would be my suggestion for us to get quarterly reports, to have that be the first iteration of this, and then we can always change it to monthly if we deem that necessary. But I think quarterly is more appropriate out of the gate, you know, as far as change. And that's, again, that's for discussion and decision next policy meeting, but I would ask you to carefully consider that. Because I think your concerns are valid.
Can we also address what Mr. Hershey said about just getting some kind of example in the past 6 months, just so we have an idea of what it is we're looking at as we shape the policy?
I would expect staff to bring us those at the next, for discussion at the next meeting. I don't know if such things could be loaded in Assembly as part of our prep materials, you know, so that we can look at it. Not specific confidential student information, let me be clear. Does that make sense? It seems to me that you all could give us examples that are not, that are, you know, don't violate student confidentiality, but to give us a sense of what we're talking about.
Right.
Is that
Yes, I think so.
fair?
I think what we would share in this setting would be pretty minimal information, but enough to give you a sense of amounts, frequency, and basic type of claim. Obviously, if you wanted more in closed session, we could get into all the details of the case.
I don't, yeah. Did you have something else?
I think that takes care of it.
Okay.
Thank you.
Any other comments or questions about the settlement 8341?
Oh.
Understanding we'll hear it again next month.
And I just want to make sure that I understand. So Dr. Crane will bring back some language that delineates the special education services different than the designee for special education
Yes,
services.
I heard during the discussion,
Okay.
3 distinct
Yeah.
levels. The superintendent, up to 30,000, reports 10,000, anything over 10,000. Quarterly is the suggested language. The next recommendation was for superintendent or designee, the designee being specifically in special ed, whether by title or just departmental designee, up to $30,000, over $10,000 reportable to the board. And then a final layer that is the superintendent or designee, up to $10,000. The superintendent's designees are identified in the R&P.
So if it's not special education, and if it's over $10,000, the superintendent's approval would be required.
Thank you.
All right, thank you. Let's move to 4023, pregnant, parenting, and lactating students and employees. And I will, I want to lift up our former colleague, Ms. Mahaffey, because I believe she shepherded this originally some years ago. So
I'm going to introduce, we have both of our Title IX coordinators at the table. We have Dr. Gia Hoke, our Title IX coordinator who handles students and student issues. And we have Sally Kowski, who is our Title IX coordinator for employees, along with Carla Withrow, who is our senior director for employee relations, and Dr. Matillo, as you guys know, is our assistant superintendent for human resources. So we have lots of folks at the table with a breadth of knowledge and some to talk you through some important updates that are based on the 2024 Title IX regulations for our students and employees.
thank
So we'll
you.
have Dr. Hoke kick us off.
Hi, good afternoon, everyone.
Good afternoon.
I will provide everyone with first an overview of the revisions, and then after the revisions, I will make 2 possible recommendations. So we are going to start with Section A, and I would like to discuss the substantial revisions in Section A and 2 minor revisions in Sections C, all of which describe how we will support pregnant parents and lactating students. Section A has been identified as the section for students, and in Section A, we have new headers. Section A also provides its readers with a definition and description of pregnancy and/or conditions related to pregnancy. When you take a look at Section 2, the general requirements, it is the law, and modifications cannot be made in this particular section. Sections 3 and 4 are new. Section 3 will address the requirements to contact the Title IX coordinator. And Section 4, if you take a look at Section 4, it will detail the specific actions to be taken by the Title IX coordinator to support students or to prevent sex discrimination for students who are pregnant or parenting students. And the recommendations that I would like to make would be, if you go back or return to Section 2, the 12th line from the top of that section references parent and parenting, and I am seeking permission to see if the word co-parent could be added, specifically to include the fathers.
Section 2.
The 12th line from the top of that section, you will see the sentence will start with homework and makeup work will be made available to parent and parenting. I would like to include co-parent in the wording there, please.
Yeah, that, which would be, that, I believe so.
Instead, does that work for you? So this, the regulations use the phrase biological parent. So that would mean whether the biological parent was the mother or the father. If the father is taking the child to appointments, dropping off at daycare, picking up from daycare, and is experiencing some challenges at school, the biological parent, whether custodial or not, would be supported in their co-parenting.
Correct.
But we're not seeking to put biological in our language, just rather co-parent, correct?
Well, I was stating co-parent, but I think that, Julie, you were saying to use the term biological, if I'm understanding you correctly.
I'm wondering if that's a better don't know if that's a better phrase or not. It's a more specific phrase.
I guess either way, you'd be going beyond the Title IX requirements, and you can certainly choose to do that. But just so that I understand this, that you would be suggesting, this is in the sentence about homework and makeup work?
Correct.
And so you'd like to extend that to
Exactly.
both parents if one parent is pregnant, so that it could be, right, so.
Exactly, yes.
Okay.
I just
Yeah.
personally feel that for the male parent who would like to be involved in the parenting of their child, to extend some type of support, because Title IX is about being supportive to
Right.
everyone, so.
Got it.
I prefer co-parent because I don't want to assume student dynamics between two individuals parenting a child. So I prefer the phrase co-parent, but Ms. Rice, I saw your hand.
No, I was just saying, great observation and work, because this is a dual role, as it should be, from a woman who has sons, whose grandchildren literally live with their fathers, considering they're no longer together. So yes, that's great.
Ms. Gordon, did you have something?
No, I just wanted to echo what you said. I totally support the wording of co-parenting versus biological, because biological, you can get tricky and in the weeds with that one.
I agree.
And I don't think that that's our place to.
So that's your first recommendation?
Yes.
And your second is?
And the second is in section 3A. And it is midway in that paragraph where you see the words, the principal. So the sentence starts, for complaints involving breaks, the response time may be extended if additional time is needed to determine an adequate break schedule, but in such instances, the principal. I would like to recommend that we also include the Title IX coordinator. So to include notifying the Title IX coordinator in that particular section.
Can you tell me again where you were? 'Cause
3A.
I'm looking at
Under the complaint process.
C3A. Okay.
My
Second to last,
apologies.
second to last.
Okay.
C3A.
Yeah, there's two threes.
Okay, C3A.
Yes. And where we see the word principal, that the principal would be notified,
So the first sentence,
midways down is where I was looking.
the principal shall promptly notify the Title IX. Is that where you are?
Yes.
Okay.
To include the Title IX coordinator, so it's actually the sixth sentence down from the top is where I'm referring to in that section.
It's the last reference.
So you were right, Mrs. Edmonds. And it should be in blue writing.
Yeah, it's already there, right?
Yep.
That's just pointing out, this is not a legally required change, but Ms. Hope is recommending it, but these changes are
Oh,
here, I
okay.
believe,
Thank you.
right? They're already in the
All right.
yeah.
And that is it.
So I'm not understanding this part. So we're in
In section 3, C3A, you see the language in blue? That's what
3A.
the language in blue is what Ms. Hope was referencing. It's already here. She's just pointing out that this is her recommendation. It's not legally required.
Gotcha. Okay. Thank you for that clarification. I was looking for where she was trying to put something and got it.
And there are minor changes to the employee section if you'd like to move over those now, unless you had more questions about the student section.
Are you referring to C3B?
The employee section is just B, employees.
Back up? Okay, got it.
And if you want me to wait, it's fine. I wasn't sure if you were ready for me or not.
No, did you want to ask now? Okay.
So I'm reading this, and I'm reading our equal educational opportunities, athletics. What is how do we handle that when a student who's pregnant wants to play a sport that has put their pregnancy in danger? I don't know how to ask that.
I understand. I believe I understand your
Yeah.
question. My understanding is we cannot require a doctor's note unless we require a note for all of the participants. That is my understanding. So although she's pregnant, if we require that all of the students turn in a doctor's note, giving permission or saying that they can play, then we can ask for it. If we do not, then although she's pregnant, we cannot ask her for a note.
And where liability, there's no liability then on us if something tragic happens because they've elected to play.
I will ask our attorney. to
I'd say your liability would be limited by the fact that you're complying with Title IX regulations. You know, complying with the law is not likely to be a source of liability. If that were the argument, that it was irresponsible to follow the law, we would say we have no choice.
Okay.
Mr. Haggerty and then Ms. Caulfield.
I mean, I had the same concerns that Mr. Hershey had. The language, and it's not necessarily the language that's being changed today, but it is the language in the policy under the general requirements that we will not exclude from any extracurricular activities and will allow access to any activity provided on a comparable basis to anyone else not in that status. I mean, it does seem like we're guaranteeing a right to participate in activities where there could be a legitimate health risk. And so how do we balance that?
Mr. Haggerty, that language is almost exactly out of the regulations, 34 CFR Part 106, that says in number 5, for certification to participate, a recipient must not require a student who is pregnant or has related conditions to provide certification from a healthcare provider or any other person that the student is physically able to participate in the recipient's class, program, or extracurricular activity unless the certified level of physical ability or health is necessary for participation in the class, program, or activity. The recipient requires such certification of all students participating in the class, program, or activity, and the information obtained is not used as a basis for discrimination prohibited by this part.
Okay, so it's that last sentence, because typically, almost, if I believe, I'm looking at our athletic expert, almost every varsity, junior varsity sport requires a physical to participate. At least all the ones my children have participated in have required all students.
Right.
And it's not, so we're not violating anything.
Correct.
Because we're asking everybody
Correct.
to participate. But that last sentence, if everyone's getting a physical, but you have a student in the 8th month of pregnancy, does that say that we cannot exclude them from an activity, even if it could jeopardize themselves or the child?
Not for being pregnant, but you can exclude them if they can't pass the physical, I guess. If the physician won't certify that it's safe for the student to participate, they can be excluded. But what's, I think the law says is you can't exclude on the basis of pregnancy, per se.
But I want to be clear, so by pass the physical, what do we mean by pass the physical? Is it that the doctor has deemed it safe or unsafe? Or the doctor just simply says, well, they're pregnant and doesn't give any
Right.
recommendation?
It would be helpful to answer that question to see what the forms, the athletic forms say. I don't know if we have access to that immediately. I would imagine that there's a certification of fitness to participate in a specific activity, but I'm not sure.
So, and I think I know whether,
Dragonfly?
let's consider, I do a physical in September to participate in girls' basketball. But I become pregnant at some point, and now it's February, and we're in the playoffs. I want to be clear that if brittle pregnancy or whatever the case may be, if I pass the physical, and now that the girl is pregnant, and much later, we're not in a position where we can say, well, I'm sorry, you're at a point to where we don't believe you can participate. And it sounds like there is no requirement that we can have her to go back and get something to clear her. Is that, because I think that's the point that you're making, Mr. Chief?
Yeah, I think so. Again, it's not in any way to have any sort of restriction on activity in any other situation. It's just that there are a limited number of activities where there could be a health concern, and then who makes that concern? Do we require the doctor to give an opinion, or is the doctor just stating a fact and not making a determination? And then if it falls on the school to make the determination, does that put the school at risk of violating Title IX?
Ms. Rice?
I just want to say I really do appreciate my colleagues' thought process and intent of asking that question. But I feel like I would like to be able to speak as a woman who's had 4 children. We see many women in sports who are pregnant and play throughout the duration of a process. While I do honestly hear the intent of what my gentlemen men are saying around the table, it's one of those things that, that's a different lane that you might want to reconsider as a female. I do also hear the fact that you're talking about the liability of the district as a whole, but unfortunately, as you talk about that liability as a whole, you still talk about a woman's body and what she is and is not capable of doing. And while I do sincerely hear the concern from a male perspective, you are not the female in that space, and females have proven that they can do certain things. As a matter of fact, as a female person who's had 4 children, the doctors will often tell you, and Dr. Ing is here, I don't know if he's not an obstetrician, but you can continue to do your same activities to a degree until it's uncomfortable for you. And so I think that's the thing that I just want us to be aware of. I'm not saying that you're wrong. I'm not saying that that's not something to consider. But I don't want us to think that we can make that choice for people. But I think that it's, with any other thing, to the attorneys that are around the table, if someone is the same, it's just like saying, for instance, I can say with my own kid, when he had his physical, there are certain things this doctor said he could not do because he had sickle cell. Playing football was a complete no. Contact sports was a complete no from the physician's point of view and his medical health. And so I don't want us to make it, while there are some delicate situations with us as being pregnant, it does not mean we are completely handicapped. It does not mean that we cannot still do what we need to do. And I've seen women do that, the Venus and Serenas of the world, of playing tennis, who are champions, they still can do that. So I just want us to be mindful of the conversations that we're having, even though it is with good intent. I do see that, I do hear that. But as a female at this table, for me, I feel like that my male colleagues are getting in the weeds of telling me as a woman what I can and can't do physically with my body just because I'm pregnant.
So,
And again, Mr. I know that's not your intent.
That's not
but
at all what I
this-
said.
as a woman,
As a woman,
I think
that's
we're-
what I hear within my colleagues, and that's the same opinion that you have, as this is the opinion that I'm sharing, so that we're clear.
we're largely discussing minors. Not in every case. I understand we have students that are 18 and older in our school district who could fall in this category. But I am interested to hear, what the regulations state, what we should consider at being thoughtful that these students are in our care, for their school day. So,
Dr. Matillo shared a copy, or just showed me on the screen, a copy of the North Carolina Athletic Association medical form, and there are multiple options on the form for the physician to say cleared for all sports, cleared for certain sports, cleared with some restriction, not cleared at all. So there are options on the form for the medical professional who signs the sports physical
Yeah.
So long as that's required for all students, the
And it
law
is.
does not prohibit
Right.
that from being used to exclude a student, pregnant or not. As if the physician says not safe to participate in contact sports, then you can.
But that does
exclude on
not
basis.
address what the example Dr. Taylor had, which is something that was in my
Right.
mind as well. If a student passes this physical in September, but then you fast forward to February, we're in a different physical state. If we can't ask the student to go back and get a physical again, that's fine. But it's just considering that scenario, what liability would we have, if any? Is that covered in, not legislation, that's regulations, or are there?
That's a great question. I don't know the answer. It's not addressed in the regulations. I
Okay.
can scan them, but it may very well have it something that's been addressed by OCR, the Department of Education, and investigations, or maybe
Okay.
case law on that. We could look into that and
Yeah.
report back. It is a good question.
Ms. Caulfield and Dr. Ng.
Thank you. I appreciate everything that was said. And I think the policy, the way it's reading, is not necessarily addressing that they can't, because we know that we're capable of doing that, being pregnant. I think more liability purposes. So since we're covering the discrimination part, would it be wise for us to put something, because that's what I was going to say, is that the medical forms that we have to sign through Dragonfly does have the doctor say specifically the level. You can play all, you're limited, whatever. But in Dr. Taylor's circumstance, where they were to get pregnant during the semester or the year, could we add some language that would say if they were cleared, better said, but I'm just throwing it out there, if they were cleared and then became pregnant afterwards, that it is recommended to seek doctor advice for them to continue playing in athletics? Would that help cover us from any kind of liability if, God forbid, something were to happen?
So Neil, I'll let you respond to that, but I think that is the essential question, that I think Title IX is clear that we can't discriminate if a lady is pregnant, if a female is pregnant. So I support that in the policy, but I think what we now recognize is that if something were to happen after that, the question is, what liability does the board take on it? I think that's what we're trying to answer, not that we're not in line with what Title IX says. I think we're in agreement with that, but,
This is great. That's
So
the
that's what I
issue
was
for
saying, if
follow-up.
we just put in language of it's recommended, that it's our policy, I mean, how else are you going to go about it? I mean, you can't tell them they can't play.
And I don't know if Title IX will even allow us to do that, but I'll let the attorney speak to
But you
that.
can't tell people what to do with their body.
So actually,
That's what I said.
if I might,
Yeah.
you can't discriminate, but the question is if you have a changing medical condition. And so what I'm wondering is how we handle things. For example, you're cleared to play in September, and again, this will be a male athlete, and then he gets a concussion, right? His availability to play, his safety to play is now changed because of something that has happened. The condition has changed. So what is our policy, like how do we clear athletes of any gender, any race, any sex, anything, any physical condition, if that changes during like the course of the year? So we're not discriminating against someone because of, say, pregnancy, but rather, again, if somebody has like a stroke or has, like I said, a concussion, how would we determine there?
Everybody can get that, Chair, but everybody can't get pregnant.
But my point,
But I hear you, concussion protocols is one thing, but a pregnancy protocol is another thing. You see what I'm saying? So no, I hear your hearts. Like I really do sincerely get that. But I also, unfortunately, because it is a gender role situation, it makes it extremely difficult to make what we around the table, I think, are trying to make reasonable decisions about. I mean, I don't think it's unreasonable.
So grateful for our Title IX friends.
Yeah.
No, Chair Haggerty, I appreciate, your intent as well, but I want us to be sensitive to the fact that an injury is, and a pregnancy is not an injury, right? But I understand the spirit in which you're
it's a
bringing that
changing
up.
medical condition.
Correct, right. But what do you all have before? And I will come back to you, Dr. Ng. Any help in this area?
I don't know that any of us can, at the table, could probably speak to that. We would probably want to consult with Darren Coe and others about, what are the current protocols for changing medical conditions. I agree with what's been said, that what's clear in Title IX regs is you can't treat pregnancy differently.
Right.
But you can have reasonable health-based concerns that are applied across the board. So it makes sense to me to say, is there some protocol? We've observed the students coming to school. We know he had a concussion in the last football game. His physical on file says he's clear to participate in all sports, but we know he just had a concussion. Should that kid be done? There's probably concussion protocols. That's maybe not a good example because there's other statutes, but you could imagine any number of different conditions, physical conditions that could, and so I don't, unless anyone cares to speak up, I don't know that we know the answer to that.
Let me ask
What's
this.
the protocol?
If we did put some kind of language, I like that you use the word recommended and not required with your suggestion of recommended to get a reevaluation if something changes, and not mention the word pregnancy, so that we are not being discriminatory. Does that help us with liability at all?
A recommendation to do what?
So Ms. Caulfield made the recommendation to add to the form, to the athletic form, that, should your medical condition change during the course of the school year, but keep that broad.
So that may already be the requirement. I would suggest if that's a question of interest, we check with Darren Coe and others and report back on it. It may well be that there's already clear protocols of that. There may be CHSAA regs on that. I just don't know. But it's not really, either way, if it's not a policy recommendation, if it is, even more important we study it, but we could certainly.
No, it's not, no.
You can't get on
Just-
Dragonfly to see the language.
Right.
You need codes to get onto their website to see any of the
And
forms.
is it a state, is the health form a state form or a county form? That's what I was just asking Dr. Taylor to look up. You know what I'm saying? Because we're talking about changing the form. We can only change it if it's our county form. But if it's a state document that's required across the state, then we can't just change that. But like, again, I do hear the heart and spirit of changing the language of any health condition, so it's not targeting, so it can be gender neutral.
So on the form I'm looking at, it does say that the North Carolina High School Athletic Association Board of Directors reviews annually the form, the approved form, and they have an advisory. But this is an old one. I don't know how often they do that or have done that.
And in terms of pregnancy, and Darren did communicate back, he said the state physical forms ask about menstrual cycle, but not pregnancy, and pregnancy would not be a disqualifier for participation.
Yeah, that's fine. I don't think it should be. I just want to, my only thing I was raising was, are we liable for anything? And the coaches, are they protected, that sort of thing? And if the girl can play, she can play. I don't have any, that was never a question for me.
Okay.
That's just like, are we liable for someone with a heart condition that the doctor says they can play?
Right, we just
Right?
want to make sure we don't
We're
have.
not liable for that kind of stuff.
We just want to make sure we don't have a policy that's in conflict with that.
Right.
That's all. Yeah.
And it, again, for me, it's the whole question of a change in status from the time that is done to later in the school year. But with regard to policy, are we good to accept the suggestion of, I had it on my note. Here, the co-parent language, I've heard consensus around that. And Dr. Ng, I forgot to go back to you. Did you have some concern or question?
I mean, speaking as a physician, you're a physician here, right? I feel like this is all common sense. I think the policy as it is fine for this particular policy. I think it's common sense. If we need to have some things where we recommend a return to play of any kind, based on any change in medical condition, I think it's wise for a student or the parents to talk to the student to go get, an opinion about whether it's safe to return to play. There are strict guidelines, for concussion. There's strict guidelines for that. So with regards to pregnancy, still, I think it's still common sense to seek the medical advice for how in what ways within the relationship between the doctor and the patient, who and the doctor knows this particular patient and how to provide the guidance for any kind of activities, or of any kind of strenuous kind of activity. I think beyond that, I mean, even as a physician, I can give the guidance, but I'm not going to watch them on the field and say, no, you can't do that. I'm not going to do that. I'm just going to give my professional opinion and my guidance. So I think the recommendation language is something that we can certainly consider for return to play or return to activities.
But not in policy.
I think this is fine. I think we don't have to change anything in this policy.
So I do want to move us along, so I'll get Ms. Caulfield and Ms. Rice and ask that we wrap this up, and I will ask for a motion.
I was just going to be quick about it. If we're not going to put it in the policy, that's fine, but the reason I was saying recommendation is because if we are talking about a young teenager who has not been through this kind of thing before, it's just proactive language to say that we recommend because there has been a change. And it's not discriminatory to say that they can't, but they don't know without seeking medical attention first that they could have an at-risk pregnancy. And here they are jumping around on the field and something could happen. It's just proactive language, that's why I was saying to recommend it to seek doctor advice, because it has changed since your first physical, saying you've checked all these things and you're fine. Now you go back to the doctor, you're pregnant, and they're like, well, actually, there's a couple of things that we're a little concerned about, so maybe you shouldn't play lacrosse. But that's between them. It's not, this policy is about discriminating, but that's why I was just thinking, putting in the recommendation language.
Ms. Rice?
I wanted to shift from that conversation, but just want to say that Kira Walsh Jennings won her third gold medal in beach volleyball while unwittingly 5 weeks pregnant with her third child. So just data on both ends, as well as what our attorney has already responded back to us in that. But I wanted to shift to the policy, if we could, is what my question really was about. I was just curious about it is page 4, policy, 4023. It's C2. I just had questions about lactation break times, the way that I schedule, the way that the policy is written. Students should work with their school counselor to create a lactation plan prior to students returning to school. That's reasonable, and then a reasonable efforts. I just wanted to know, have you had any complaints around? I don't know how many of our students actually get pregnant during the school year.
Yeah, I have never had any pregnancy students come to my office at all.
That had challenges with the
None have ever been reported.
Then I have nothing else to say about that. I just was curious.
Thank you. Okay, can I get a motion to move 4023 to first reading?
I'm sorry.
Yes.
We didn't cover the employee side.
Oh, you're right. I apologize.
The employee they have one.
No, you're right. Thank you.
Recommendation.
I appreciate that.
One revision there. Sorry, it's in section B.
Yes, it is section B, and it's just simple language that, for the revision, where they've added the sentence to say that pregnancy or related conditions will be treated as any other temporary medical condition. And then the School Board Association recommended striking through the reference to prohibition against discrimination, harassment, and bullying, but staff wanted to keep that language. Discrimination is referenced in the first sentence, And so we just wanted to keep that reference in there, so that's why that's blue. And then even though you see the strike through of that last sentence, pregnant and nursing employees will be provided accommodations as required by law, if you look at the following sentences, it covers providing accommodations. So we're not eliminating accommodations, it's just explained in the next sentence.
Yep.
So they recommended that strike through there.
Okay. Questions, board members? All right. Thank you for that, walking us through the employees section. My apologies. So can I get a motion for 4023 to go to first reading on November 18th on consent?
So moved.
Second. Ms. Rice, motion, and Ms. Caulfield, second. All in favor, please say aye. Aye. Any opposed? Thank you. Thank you, staff. We appreciate you helping us through that. Moving on to 7920, reduction in force, and 7921.
Okay, 7920 is reduction in force for contract employees. And what you'll see for this policy, the black text is the School Board Association recommended text. The blue text is mostly where we've taken from current policy and embedded our current practices into the School Board Association recommended policy. Where you see a blue strike through, it's where we wanted to make a change to some of their recommended language. So basically, in that first paragraph, you'll see additional language that we've added to the School Board Association policy. Just further explaining contract employees, where we changed the title. And that was from previous board meetings where, you know, in the past it was like licensed or non-licensed or classified employees. And so we're trying to change that language. And so you'll see we changed that to contract employees. And then we've added language to define that. Then if you move through the policy, you can see in number 3, section A, number 3, it's on the second page, we've added this huge section from our current policy into the recommended policy because we liked the way we defined it to help employees through this process. So we wanted to keep that more detailed language here to help define our groups. Then we go through and add more language in section B from our current policy, which talks about being able to transfer employees and help employees in other ways through this process. Then in section C, we've actually reduced some of that language in section C to provide the district with more flexibility to be able to find ways to assist employees. We didn't want to pigeonhole ourselves with some of these restrictions. So this gives the district more flexibility so that we can better help employees through this process or find another location for them, use another licensure area so that we can help find a spot if we need to have reduction in force. And then in section D, also from current policy, that also provides the district with flexibility to have exemptions. So we could say this employee is exempt or this type of employee is exempt. And so we wanted to keep that type of language to also be able to help more employees through this process. And then you see some other wording changes where we change from teacher to employee. On the last page, you see a lot of references. We're just changing the wording to be more consistent.
Okay. Board members, questions? Mr. Haggerty?
Thank you. So there's a lot of blue, and I just want to make sure I know what it means. But the first question, it's two questions. The first question is in section A, subsection 3, the language that's brought in under financial exigency, the previous language said that the financial situation means any significant decline in the board's financial resources that compels a reduction in force. The new language that is brought about by the decline in enrollment, comma, or by other actions or events, I mean, that really just means anything. So do you really need any of that blue language? You're defining it to mean, well, it could be this or it could be anything else. So does the definition really matter?
I can tell you that in putting that language in there, one of the things that we attempted to do, that Sally and I were asked to do, was to take a look at 7920 and 7921 and look for opportunities to make the language parallel. And so that is language that exists in 7921 as part of the School Board Association's language. We haven't opened 7921 yet. But I'm looking there under financial exigency. It does say decline enrollment or by other actions and events. And it follows that compels a reduction in the school system's current operational budget. So that was an effort to make them parallel, if you don't think that's necessary.
So if I may, then I'll just apply that same question to the other policy as well. They might both match now, but how strong or meaningful is that definition different than the existing definition? You know, again, that is brought about by the decline in enrollment. All right, that gives you more definition. But, or by other events or actions. So that's everything else other than the decline in enrollment. So it just doesn't seem like it defines anything.
I think that it would be hard to provide a list of circumstances
Right.
that would qualify for this reduction in force, so it needs to be a little open-ended because I don't think we could exhaust the list.
Yeah.
So in some way, and we can definitely look at this wording and change it, but in some way we need to leave it a bit open-ended to encompass any situation we might encounter that would require a reduction in force.
And I totally agree with that. It's just that if you are keeping it open for the reasons you stated, do you really need this amendment to it, which doesn't really mean anything?
Like why even say enrollment?
Yeah.
I mean, I could see part of this really was mirroring both policies, but you bring up a really good point that just simply saying a decline in the board's financial resources should keep it broad enough. So I certainly would support striking that in both policies and just keeping it broad with that first clause.
I'm checking to see, I have this vague thought that this language might have come from a statute, but I'm not finding it yet. I'll check.
Okay.
One other thought, though, is that, because I totally understand your point, Mr. Haggard, is like you have two specific examples and a broad catch-all. Why do you need the two examples? One option would be, since just because those first two examples do, that there are things that happen, these are patterns that arise, even if it's not legally required, is you could make the, just add, say, in the last one, C, or any other insufficiency of funds to make it clear that the first two are more specific examples. Or delete. But I do want to check to make sure there's no, I just have this thought that declining enrollment, it may just be that it's always been in the NCSBA policy and that's where I've seen it, but I want to make sure it's not in the statutes before we talk about removing it also.
And then my second question is just more broad. I think the thing that we all care about is when there is a reduction in force, then how do we determine who's affected? Is there a formula? Is there an evaluation? And it seems, if I read the policy correctly, it does give the administrator, a fair amount of discretion. It simply creates these certain factors 1 through 5, these criteria that you can use in judging like the order. It's not like an automatic first in, first out, or last in, first out sort of thing. I just want to make sure that the impact of this is what I think it is. Is that right? That it sets it up with the determination being influenced by these criteria, work performance and evaluance ratings, areas of it looks like licensure and program enrollment were struck, but then service and extra duty positions, tenure of service, and then other criteria from the superintendent.
And once in that section number 3, under A, it does talk about grouping employees into those very specific focused groups to define the pool. And then once you get that more focused pool, then you can apply the other things to determine who out of that limited pool would be part of the reduction in force. Yeah.
Great, thank you.
And I did check the statutes. I'm not seeing the decline in enrollment that's in statute, so I do think you could either reject those two, or the other option would be add some language in C that would say, or any other, to make it clear that the first two are just specific examples. Either one.
Ms. Boardman?
Thank you. I want to say, first of all, that I appreciate the intentionality around changing the non-certified to non-contract personnel. I do want to say, however, that I'm not crazy about that. I think changing it to educational support professionals is a much better way of showing our commitment, the district's commitment to the relationship that we hold with educational support professionals. I think contract sounds very like for temporary work, and our educational support professionals that are employed with the district are very much permanent. So I want to say that, but I think my question kind of speaks to more of the next policy, which is the 7921. So if you want me to hold off, I will.
No, if it's related, I think, go ahead.
Okay, so in reference to the 7921, I guess what other contract employees would that policy refer to?
So
Outside of educational support professionals.
So 7920 would be employees with contracts. So that's your teachers, your
Right.
principals. Some central office personnel have contracts.
Right.
And the biggest reason for me that we use those words is from a legal perspective of trying to legally defend which group we're talking about. Because people who have contracts have different laws that protect their employment versus people who don't have contract. Like, I don't have a contract. So I'm in 7921, an employee without a contract. So I don't have any language in, for me, like the superintendent you say, bye. Yeah, I don't have a contract. But then I think Dr. Matillo has a contract. So it's not about license. It's not about the type of job you have. It's really about, do you have a contract that protects your job in some way, or do you not have a contract where your job is not protected through that language? And so that's what we're trying to differentiate here, so that the people who have contracts, they would be dismissed or non-renewed, or they have certain rules that follow how they would end employment. And then the people who don't have contracts, like 7921, we don't have as many rules to protect our employment, and so how we get rid of someone is different, or how we end employment is different. And so that's why we have to have the two policies like that. But we're open to a different type of language. We just couldn't come up with anything else that would help define who's going to be non-renewed or dismissed versus who would just be terminated.
And you'll notice, like, if I could add in 7921, we did add language to explain who is covered by the employees without contracts, to include a variety of school-based and also central services.
Yeah, and I think they used to say things like licensed employees, but that doesn't really work because I'm licensed, but I'm over here in 7921. So it doesn't really work from a legal standpoint of how to define the two groups.
Where is that reference in 7921?
First paragraph.
Yeah, the very first paragraph, the blue portion. Like it says human resources administrator, facilities administrator. It could be instructional assistant or bus driver, just a variety of types of employees that don't have employment contracts.
Positions do not require an instructional or administrative license. So it even could be somebody like on a contract versus salary, but just not an instructional or administrative license and contract. So those would be the ones that classified too.
The key point here, just for context, is 7920 implements some statutory requirements. 7921 is more of a discretionary policy. You don't need to have a RIF policy for classified employees or however we define them. But 7920 you do, so it's important to just have a clear definite. What term you define is less important, but how you define it is important to track the statute, and that's covered here. So that the definitions in 7920 and 7921 are clear enough that we can sort employees into whether they are subject to one policy or the other, if that makes sense.
Ms. Gordon, I'll come back to you if need be. Is that good?
Okay.
Ms. Rice?
Oh, no, I have no comments. It makes sense.
Ms. Caulfield?
I was just curious, changing the language, I understand your explanation for the title, like changing it to contract employees. Is that going to be confusing with the state language?
Ms. Caulfield, I want to make sure are you referencing 7920 or 7921 since we jumped around?
I'm still on 20. So
Okay.
we changed the language from teachers and school administrators, I get that, it's in our policy title, but when we're calling them contract employees, it seems like trying to clarify and simplify the language that we know which categories we're talking about. Is that matching the state, how they break down the pay?
The definition here, this policy applies to one, employees with career status, and two, all other teachers and school administrators as defined in the relevant statutes. That's the legal definition that we need to make clear. So if there were a RIF, it's important that, there's no ambiguity. Any employee knows whether they're potentially subject to it or not, and that gets you there and it tracks the law. Does that make sense?
Yes.
I think the question is what phrase to use, and I think staff are saying contract employees is what they came up with as a more neutral way to avoid, licensed versus non-licensed or certified classified, which, may be confusing to some people.
Just for clarification, in 7920, the letter F, the title, termination/reemployment of a teacher with career status, should that be modified too?
I'm sorry, where were you?
At the bottom, page 5.
Page 5?
F. So F.
Because you changed the body of it says you strike out teacher and replace it with employee. So I just wasn't sure whether that title should also reflect that change.
Oh, I see, yep.
So should it be contract employee?
It's the employment of an employee
You could just say
with
an
career
employee
status.
with career status.
Yes, yes.
That's a good catch. That's just consistent.
Can you state the change, please?
Letter F, termination/reemployment of an employee with career status.
We changed it throughout the policy, but we missed that one, yes.
Mr. Hershey, did you? Ms. Gordon, did you have any follow-ups?
No.
All right.
I do believe these two, these two differential titles, contract employees and employees without contracts, are titles that we used in policies we previously migrated, right? So we were also trying to, it's language that we've already established in the title of other policies that are moving through adoption. So this is aligned with other language in our policy titles.
So it is becoming.
It's just confusing to somebody reading it outside that context.
So let's move to 7921, because I know we jumped over there for a moment, but I want to make sure that you walk us through whatever you need to walk us through.
Yes, and 7921 is presented to you a little differently with the coloring because the School Board Association policy is very short, and so we had a much more detailed policy here in Wake that we wanted to keep most of it, or we're recommending to keep most of it. So what you see in black for this policy is our current Wake County Public School System policy in black. The blue is where we integrated things to mirror 7920, or made some changes mostly to mirror 7920. But then also, if we needed to add anything from the School Board Association policy, it would be in blue. But honestly, most of it is was already embedded in our black text. But if we needed to make a few adjustments, then you would see those in blue, those suggestions. And again, the two policies do mirror each other as much as possible, other than how we would end employment would change because of either the contract or the lack of a contract.
Mr. Hershey?
I may have missed this in the previous one. I don't understand the point of the sentence. I just lost it, 6, why we're saying, after exploring, considering, and discussing a variety of ways to avoid a reduction in force. Why is it not just if the board determines that a reduction of force of employees subject to this policy is necessary? Like, some of our sentences just go on forever.
Yeah.
And I don't feel like that's necessary at all.
Yeah, and we can certainly cut it out. I wanted to try to find a way to communicate to our employees that we will do everything we can to avoid using this policy, so that's why that introductory language is there. But if you all do want to strike that, we can certainly do that.
I would strike it. I think the board does that anyway with everything, and by inferring that we're just doing it here might infer that we're not doing it elsewhere. And it's the board's responsibility anyway to consider issues and
Okay,
discuss
so
them.
strike, I'm going to say B6, 7921, the...
After exploring, considering, and discussing a variety of ways to avoid reduction in force. Strike that whole part.
So it just reads, if the board determined that a reduction in force
It's necessary. It's still a necessity standard, so it's not.
And then there are 3 other things that I want to bring to your attention that are not corrected. We have in 3B, under section B, it says the number or estimated number of non-certified positions. We need to get rid of non-certified. It still exists in 3 places that we notice, so we need to get rid of those. One is 3B, one is at the end of number 4, and it would just say a reduction in positions, because we've already defined it. And then on the last page, in D, board decision, again, we would just strike through non-certified, specifying which employees, if any, will be terminated or demoted as part of the reduction in force. Because again, I'm part of this policy, but I'm certified, so it doesn't match.
Any other questions or comments about 7921?
Just one more, if we're going to consider Board Chair Haggerty's deletion of the phrase and the other one, do we want to consider it here as well?
Yes. And because this has had several changes, I think what I'd like to do, and this is not ask for a formal motion, I'm trying to take a temperature. I think so that we can see these edits, that perhaps we should put 7920 and 7921 on action on November 18th, just so that we can see where these edits have been made. Okay, but that's not a formal motion. Ms. Caulfield?
I just have one quick question, and it's on 7920, so I apologize, but on page 5, one of the things that we removed, that the superintendent shall consider a variety of factors, is program enrollment. And I was just curious why we had to remove that.
It just limits our flexibility in trying to save employees. If it's just program enrollment, if we leave it there, we'd have to consider that. Well, we took it away because we don't want that to just be the factor. We want to look at our groups and then determine, based on these few things, who needs to go. If you use program enrollment, it limits you more.
Right. Okay. Thank you.
Any other comments, questions? So I'd like to entertain a motion for 7920 and 7921 to come to action at the November 18th meeting.
So moved.
Second.
All right, all in favor, say aye. Aye. Any opposed? Great.
Mr. Haggerty moved. Who seconded that?
Ms. Caulfield?
Thank you.
All right, thank you all. We will adjourn at 2:57.
Keeping our